Hi, welcome everybody. This is Danilo Ruggero Di Bella from the law firm Bottega DI BELLA, and today we will talk about how to start from scratch an ICSID arbitration. This means we will go through the applicable rules of procedure to initiate an investor-state arbitration before the International Center for Settlement of Investment Dispute, or as we will refer to it during this presentation, the ICSID or simply the Center. Furthermore, we will see how to draft and submit a request for arbitration and how that request is processed by the ICSID. The applicable rules of procedure can be represented effectively by a 5-layer structure. So I want you to imagine, as I'm talking, that we are moving towards the core of such structure. On the outer layer, we have the instrument giving consent to arbitration. To commence an ICSID arbitration, just as any kind of arbitration really, the first thing you need to look at is the legal instrument providing for consent to arbitrate. Such consent can be found in a treaty, in a contract, or in a national law. The treaty can be a bilateral treaty, it can be a multilateral treaty, it can be a treaty devoted exclusively to the promotion and protection of foreign investment, or it can be a treaty that in one of its chapters deals with foreign investment. The contract can be an investment agreement entered into between the foreign investor and the host state, or one of its state agency or national authority. The national law can be a piece of national legislation enacted by the host state to attract foreign capitals. The document containing the consent to arbitration can curtail that consent, meaning that it can limit the scope of an arbitrable dispute, or establish some additional procedural conditions that need to be observed either before filing an arbitration, such as a cooling off period, or the method to appoint the tribunal, or once the arbitration is over, like an agreement not to challenge the award, whatever the outcome may be, or the commitment to execute the award. On the next layer, we have the ICSID Convention. Although there is a significant room for parties' autonomy under the ICSID Convention, there are some provisions which are mandatory, meaning that they cannot be overridden by an agreement of the parties. For example, Article 25 of the ICSID Convention, which set the jurisdictional requirement, razione persone and razione materia, of an ICSID tribunal. Article 36 of the Convention deals with the request for arbitration. In its second paragraph, it enlists the basic contents of a request: information about the dispute, the parties, and their consent to arbitration. I will come back later on the contents of the request for arbitration. The next layer consists of the administrative and financial regulations and the rules of procedure for the institution of conciliation and arbitration proceedings, commonly referred to as the institution rules. As to the administrative and financial regulation, they specify the official languages of the whole proceeding, and therefore the language in which the request needs to be submitted. They set a lodging fee to register the request and establish the criteria of the supporting documentation that goes along with the request, respectively in Regulation 34, Regulation 16, and Regulation 30. The institution rules instead set the form and substance of the request for arbitration. I will delve into the institution rules as I outline the structure of the request for arbitration. On the next layer, we have the ICSID rules of procedure for arbitration proceedings. Quite a redundant name, right? Commonly called the ICSID arbitration rules. These rules are relevant with respect to the filing of the request for arbitration to the extent that they set the method of appointment of the tribunal, failing any indication to this effect in the request for arbitration itself. Such rules complement the framework of the ICSID Convention and are amended from time to time. The latest version in effect is the one from 2006. So far, the arbitration rules have been amended 3 times, in 1984, 2003 and 2006, and currently the ICSID regulation and rules are undergoing a new amendment process. In this respect, it is important to highlight that the applicable arbitration rules are those in effect at the time of consent, meaning when consent was perfected, as opposed to the procedural rules of most arbitral institutions. This entails that, for example, if consent was given 20 years ago because it was embedded in a contract that came into effect in 1998, then the rules in effect back then would apply. Those rules would be the 2003 arbitration rules and not the 2006. Now, what happens in practice is that, out of convenience, parties most of the times agree to apply the most recent set of rules. This is the standard practice. If instead the respondent state's consent consists of a standing offer to arbitrate containing a treaty, then the moment when the party's consent is perfected is when the investor accepts that offer to arbitrate by filing an arbitration. That's the moment that counts for the purpose of the second paragraph of Article 25 of the ICSID Convention, letter B. Finally, for the sake of completeness, on the inner layer of the rules of procedure applicable to an ICSID arbitration, there are the procedural orders issued by the tribunal when the proceedings are underway. I mentioned the procedural order just to give a comprehensive picture of all the applicable rules of procedure, since procedural orders do not have a bearing on the request for arbitration, simply because when the request is submitted, the arbitral proceeding hasn't begun yet, obviously. Now that we have seen the procedural framework to institute an ICSID arbitration, we can look at the request for arbitration more in details, and then we will see how the request is processed by the center. The filing of the request for arbitration to the Secretary General of the ICSID is the first step in an ICSID case. As we have seen, the request is governed by the Article 36 of the ICSID Convention, the ICSID Institution Rules, and to a less extent also the ICSID Administrative and Financial Regulations. Especially the institution rules and the regulations shape the form and the basic contents of a request for arbitration. The request needs to be submitted in writing, either in English, Spanish or French, to the Secretary General of the ICSID in Washington, D.C. The requesting party must enclose 5 copies of it. The request must indicate whether it has been filed for an arbitration or a conciliation. So far, I'm aware of 11 conciliation proceedings that have been filed with the ICSID, all involving African states with the exception of a Caribbean state. A common structure for a request for arbitration can be the following, as shown by this slide. We start with an introduction, where the requesting party applies to the Secretary General of the ICSID for the registration of its request for arbitration to institute arbitration proceedings against a given respondent state or a constituent subdivision or agency of that state by invoking the legal instrument providing for consent to arbitrate. The request must indicate the date of consent and enclose the instrument in which consent is recorded. If the consent is contained in a treaty or a law, the request must enclose copies of such instruments and evidence of their entry into force. For example, an extract from a government website showing the date or a copy from a state's collection of laws. If the consent is in a contract, the request must enclose a copy of the signed contract and its effective date. According to the Institution Rule number 2, paragraph 3, the date of consent is the date on which the parties to the dispute consented in writing to submit it to the center. If both parties did not act on the same day, it means the date on which the second party acted. Then the requesting party shall indicate the parties to the dispute and who represents them. The request shall provide the names and contact details of all parties to the dispute, the name and contact details of the counsel. The request shall enclose the power of attorney for the counsel. The request must indicate the nationality of the requesting party on the date of consent to arbitration and confirm, when the claimant is a natural person, that it does not have the nationality of the respondent state. If the claimant is a juridical person instead, it must indicate that it has taken all the necessary internal actions within the company to move forward with the request. And if the claimant is a juridical person incorporated in the respondent state, the request must show that the respondent state agreed to treat the claimant as a national of another state because of the foreign control. An example of such agreement is the one in the Italy-Yemen bit in Article 1, Paragraph 2, where it defines the term foreign investor as any foreign subsidiary and branches in the territory of a contracting party controlled in any way by legal or natural person of the other contracting party. If the respondent is a constituent subdivision or agency of a state, the request must enclose evidence that the respondent has been designated to the ICSID and that the state has given its consent. Then we have the factual background of the legal dispute. The request must show the existence of a legal dispute arising directly out of an investment. This is usually done by way of a summary of the dispute, touching upon claimant's investment, the measure adopted by the host state affecting that investment, the respondent's violation under the relevant treaty, contract, or national law. Then, the requesting party should indicate that its claim fulfills the jurisdictional and procedural requirements under Article 25 of the ICSID Convention, as well as under the legal instrument of consent to arbitration. Then we have a point dealing with the number of arbitrators and method of their appointment. The requesting party may indicate if the disputing parties have already reached an agreement as to the method of constituting the tribunal. Here, the requesting party may also designate its party-appointed arbitrator. Then, the requesting party may state the relief that is seeking through an ICSID tribunal. Although there is no requirement that a request for ICSID arbitration should set forth the relief sought, it is common to include a preliminary indication of the relief sought right at the end of the request, together with the reservation of the right to amend or supplement subsequently the relief sought in the course of the proceedings, as well as the right to advance further arguments and produce other factual or legal evidence as may be necessary to complement the presentation of its claims or to reply to any argument or allegation put forward by the respondent state. And finally, of course, the request for arbitration shall be dated and signed by the requesting party or its duly authorized representative. Now, the minimum content for a request for arbitration is much more basic than this one. But when you file the request for arbitration, it's the first moment when the tribunal, and before that the center, will hear about your case. So you want to use this opportunity to set the leitmotif for the whole case. So it's good not to waste this opportunity by sticking to the minimum content. On the other hand, you don't want to submit an overly long request. Ideally, in the first paragraph, you should be able to tell the tribunal what the dispute is about and why you are right. Let's say you don't want to exceed 20-30 pages for a request. As to the process of the filing of the request, this flow chart shows the steps to initiate an ICSID arbitration involving the filing, the screening and registration by the Secretary General, and the notice of the registration to the parties. As I said before, the request for arbitration needs to be submitted to the Secretary General of the ICSID in Washington, D.C. Under the current schedule of fees, the request must be accompanied by a non-refundable lodging fee of $25,000. This lodging fee is paid by the party requesting for arbitration and is not refundable, meaning that if the party later decides to withdraw that request for arbitration, it would not get the money back. Interestingly, a request for arbitration may be filed either by an investor or by a state, In the vast majority of the cases, the request is filed by an investor, but a state may as well initiate an ICSID arbitration. It is also curious to know that in the 80s, the lodging fee was extremely low, just $100. It was then increased to curb frivolous claims. Upon the receipt of the request for arbitration, the ICSID usually acknowledges receipt within 24 hours. Once the center receives the payment of the lodging fee, the center transmits the request for arbitration and all the supporting documentation to the respondent state. Until the payment is not processed, the request is not processed. Once the payment is done, the center sends a copy of the request for arbitration to the respondent state embassy in Washington, D.C. to make sure that the request is notified to government officials. States can, if they wish, designate recipient agency by notifying the center with the name and address of that agency. Spain, for instance, has designated the Abogacía General del Estado to this effect, so the center doesn't send the copy of the request for arbitration to the Spanish embassy anymore. A very distinctive feature of ICSID arbitrations is the center's power to review any request before registration. According to Article 36, Paragraph 3 of the ICSID Convention, the test that is applied by the center is the following. A request will be registered unless it is manifestly outside the jurisdiction of the center. The standard of this test is quite low. The center rarely refuses to register a case, but it has happened from time to time. What happens more often is that when there are some problems with the request, the center sends a letter to the party filing the request asking questions in order to supplement some part of it, and if the party realizes that it is unlikely that the request will make it to registration, it voluntarily withdraws the request in full or in part. To determine whether the case is manifestly outside of the jurisdiction of the ICSID, the center will review all the information contained in the request itself and all the supporting documentation in view of the requirements of Article 25 of the ICSID Convention and the institution's rules. If something is missing, the center will send a letter to the requesting party asking to clarify or provide additional information with respect to a given point. The requesting party is given the chance to respond within a short time frame, and the Secretary General then makes a decision whether to register it or not. For example, the ICSID is unlikely to register a case if the investor has the same nationality as the respondent state, or if the state agency was not designated by a member state as a respondent before the ICSID. Investor would have a problem if they are not national of an ICSID member state as well, or if the bid has not entered into force. Under the Rule 6 of the institution rules, the Secretary General must make a decision whether to register the request or not as soon as possible. If the Secretary General decides to register the request, she will send a notice of registration to the disputing parties. Importantly, the request can be withdrawn by the requesting party at any moment prior registration. Once it has been registered, however, the requesting party can no longer withdraw the claim unilaterally. It can only do so with the agreement of the other party. All this process of registration usually takes less than 3 weeks. Something really important with regards to the process of filing the request is that there is no appeal against the decision of the Secretary General whether the request is registered or not. That decision is final. This, however, does not prevent a party from resubmitting its request for arbitration, provided that, of course, what prevented the request from being registered in the first place has been cured, otherwise the outcome would be the same. That's about it with respect to the institution of the proceedings. Thank you for watching the whole video. You may now consider yourself an expert in filing a request for an ICSID arbitration. I would like to thank also Francisco Grob, legal counsel at the ICSID, for lecturing me about the ICSID procedure in a training session organized by the ICSID. In the description of the video, you can also download the PowerPoint of this presentation. And also my LLM thesis, that was actually a request for arbitration in disguise used to launch an ICSID arbitration against Italy, so that you can have an even more practical insight of what a request consists of.